Hello, my name is David Scher, and I'm an attorney with the Employment Law Group. Today, we want to offer some reflections after the presidential election that just took place a few days ago. Regardless of your opinion or perspective of who should have been the president or all the other offices that were elected, I can certainly tell you that us people who live here in Washington, D.C. are absolutely happy that the election is at least over and perhaps Congress can now get back to business. We wanted to highlight some of the accomplishments that have happened over the last few years that have really been helpful to employees who are whistleblowers. First of all, and in the general area of civil rights. First of all, there's the Lilly Ledbetter statute. That statute was enacted almost immediately after President Obama stepped into office, and that statute enhances the rights of women to receive equal pay for equal work. Very important statute in the civil rights arena. Also, a couple of very important developments in the area of whistleblower law. There is the Dodd-Frank statute, which allows an employee who is a whistleblower to disclose that fraud is being committed on shareholders of a publicly traded corporation. And it allows the SEC to investigate those claims and even reward the whistleblower for making those disclosures. There is the IRS whistleblower statute. Under that statute, an individual who discloses that tax fraud is being committed on the IRS, the IRS can go in and investigate and make a recovery, and a portion of that recovery can be awarded to the whistleblower. All of this provides and enhances the US Treasury, dollars coming back into the US Treasury to support our government, to support our taxpayers, all of us. Also, there were amendments to the False Claims Act, two very important amendments. One involves financial fraud. The statute has the False Claims Act, which allows whistleblowers to bring actions on behalf of the government when they feel that the government is being defrauded, has been expanded to allow for individuals to bring claims not only of fraud being directly committed on the government, but even indirectly, when they believe that there's fraudulent testing going on or products are being delivered that might be defective. In any way a government contractor is knowingly defrauding the government, the statute is expanded to allow for those claims as well. In addition, regardless of what you think of Obamacare, there's a very important provision in the Affordable Care Act that enhances protections against Medicare fraud. It specifically allows and even directs the federal government to investigate and stop Medicare fraud. As a result of those provisions, billions and billions of dollars have been returned to the US Treasury, certainly a positive result for taxpayers. Obviously, these provisions benefit employees and protects them against retaliation in the workplace. We feel it also levels the playing field. For companies that are doing things right, that are in business with the federal government, using taxpayer dollars, and are doing things lawfully and doing things right, it levels the playing field against those who aren't doing so, who are committing fraud and have been getting away with it. So for all of these reasons, we really celebrate the developments in the law over the last several years, and we look forward to those developments to continue into the future. I hope you have a great day, and if you want more information, you can check us out at www.employmentlawgroup.com. Thanks.